Hello viewers, today we are going to learn about high courts in this video. In this video, you will be learning about the high courts, and in the upcoming video, you will be learning about state and district courts. So first and foremost, we focus on high courts. Just below the court, Supreme Court, there are high courts, which are the highest court of law in the state. The high courts are part of the Indian judiciary. So it is the soul of any state, and function under the supervision, guidance and control of the Supreme Court. The Supreme Court, which dominates, as you know, the Supreme Court is the head of all courts, and the High Court is head of all the subordinative courts or other district courts, what we say. As a high courts in the state, a high court supervises the subordinative courts in the state. The high court are main courts of appeal. So these courts hear appeals from numerous subordinative courts. So the most important work of any high court is to listen to the subordinative courts and the district courts too. The system of appointing judges, their qualification and the working of any subordinative court is under the direct control and supervision of the High Court of a state concerned. At present, there are totally 21 high courts for 29 states and 7 union territories. So we have totally 29 states and 7 union territories. Overall, we have 21 high courts. The high court are the highest courts at the state level, but being part of integrated Indian judiciary, they work under the superintendent's direction and control of the Supreme Court. So whatever it may be, whatever the court, or they come under the direct control of Supreme Court. There is a high court for each state. So every state has its own high court, and there can be a common high court for 2 or more states. So there is a common court for 2 or more states, and every high court has a chief justice and a number of judges. The number of judges varies from state to state. There is no actually sticking to certain numbers, so it varies based on the states. The number of judges of each high court is determined by the president. So the president who determines the number of high courts as well as the judges. The judges of a high court are appointed by the President of India. While appointing Chief Justice of a High Court, the President has to consult with the Chief Justice of the Supreme Court. So with the getting consent from the judge, the Chief Justice of a Supreme Court, the President who appoints the judges of a High Court. So while appointing other judges, the President consults the Chief Justice of the Supreme Court, the Chief Justice of the High Court, and the Governor of the state. So when it is concerned, when it is important about when we talk something about a High Court, the Governor who plays a vital role in selecting or nominating the Justice, Chief Justice. The Chief Justice of the High Court and the Governor of the state concerned, the judges can be transferred. So the High Court judges can be transferred to any other state and it will be decided by the President. Okay, so the President who will be deciding, and he will be appointing the judges accordingly. And the basic qualification. So for the judges of a high court, what is the basic qualification, tenure, and in what way they will be removed? As such, we are going to learn one by one. So in order to in order to be appointed as a judge of a high court, the person concerned should possess the basic qualities. The first basic quality is he must be a citizen of India. So this is the basic requirement. He or she should be a citizen of India. And the next most important one is a judicial office. They should serve. Okay, they should have held a judicial office at the district level or below for at least 10 years tenure, or the most important factor, if though above they should have judicial office, and if it is not so, he or she should have been an advocate in one or more high court for at least 10 years continuously without any break. So these are the basic qualities for being a judge or a chief justice of high court. Once appointed, if the judge is being appointed, the high court judges hold office till the retirement. Okay, so till they attain the age of 62. After retirement, they may be appointed judges of the Supreme Court, or they may practice as advocate either in the Supreme Court or in any high court. So, and the most important factor we are going to discuss now, the powers and the jurisdiction of the high court. So what type of power they hold. The most important factor, the high court have the power to hear and decide cases which are brought directly to it. So the most important factor, the first important factor of a high court, they can listen. Okay, this power is called as original jurisdiction. So this is called, if the case is brought straight away to the high court, that can be considered as a original jurisdictions. When high court hears an appeal against the decision of a lower court, it is called appellate jurisdiction. So from the I am not convinced with the subordinative courts, immediately what I will be doing, that I will be appealing to the high court, and in case if I am not satisfied with the subordinative court, and if I am approaching a high court based on the judgment given, that can be referred as appellate jurisdictions. When high court hears an appeal against when high court hears an appeal against the decision of a lower court, it is called appellate jurisdiction, and a high court is mostly a court to appeal. So how shall I refer? So we can refer that a high court is an appealing court. The original jurisdiction of the high court is very limited. Cases of alleged violence of fundamental rights can be started in high court or in the Supreme Court. The high court have the power to issue orders to restore the fundamental rights of the people. So they could question if something goes against the rights, so they could question the authorities, and they could establish or restore the fundamental rights of the people of the state or district. And you could recall that there are orders, these orders, the fundamental rights, which means these can be attained through writs. And high court can hear election petitions. Okay, so the one more important role of a high court is listening to the election petition in its original jurisdiction, challenging the election of a member of parliament or state legislative assembly. And high courts hear appeals against the judgment of the subordinative courts. In civil cases, appellate jurisdiction extends all such cases.